the record. In the matter of Elena Watkins versus Donald Roberts, 25-00273. Okay. On the record, in the matter of FHC5 Capital Senior versus John Wolf, 5-00542.
Good afternoon, Your Honor. Attorney Hamza on behalf of the plaintiff.
Good afternoon, Your Honor. Elijah Tyra, PA6242, on behalf of the defendant, Mr. Wolf.
Today was the date that was scheduled for hearings for non-payment of rent. Have you been able to resolve this matter?
Yes, Your Honor. We would like to enter conditional dismissal. May I approach?
Put the terms on the record.
The terms are that the defendant agrees to pay his portion of rent by the 5th of each month, plus an additional $259 to come out on the 3rd of February of the month for the months of April on April 18th, 2025, May on May 16th, and June on June 20th. The plaintiff and defendant agreed to continue to work with the Tri-County Office of the Agent to secure assistance.
That's complete and accurate, counsel. Okay, Mr. Wolf, you understand you have the right in this matter to proceed to a trial, and you could demand a jury trial. You understand that, right?
Yes, I do understand.
Okay. I understand that if you were to proceed to trial or hearing, that would be the time that you would be able to present any of your defenses as to why you didn't pay the rent. You understand that?
Yes, I do.
Do you want to waive or give up your trial and hearing?
Yes, I do.
Anyone threatening you to do that?
No.
Okay. You understand that also means that you'll have to waive any potential counterclaims or defenses. Do you understand that?
Yes, Your Honor, I do.
Okay, so the matter will be dismissed today upon the condition that you pay the past due rent, $1,604 plus $172.85 for court costs for a total amount due $1,776.85, and that the defendant agrees to pay his portion of rent on the 5th of each month plus an additional $259 to come on the 3rd Friday of the month for the months of April, on April 18, 2025, May, on May 16, 2025. And plaintiff and defendant agreed to work or to continue to work with Tri-County Office of Agent to secure assistance. So this was the payment also June 20th, 2025 at $259. That's correct?
Yes, sir.
Okay. Yes. 3 business days from today's date. If once you leave, you realize you misunderstood the right that you've given up, you can return to the court, request to have this set aside, and we'll set it for a hearing. Partial performance is not going to satisfy this, so you need to comply fully with your agreement in this section, okay?
I understand.
Do you have any questions for the court?
No, I do not.
Any additional matters for the record? Thank you. You're all set.
Thank you, Your Honor.
On the record, in the matter of Bobby Dodd versus Robert Hicks, 24-08072. State your name for the record, please, sir. Your name?
Robert Hicks.
Okay, this is the date set for a hearing. This is for termination of tenancy, and you all cannot come to a resolution.
No, we haven't spoken.
Okay.
I'd just like to get my house back.
Okay, this matter is not tied up in probate court, is it? It's not? Okay. No. Okay, so you have full ownership of the home, yes, correct? Okay. Do you have a lawful right to hold over the property?
I have to speak on behalf of my mom.
You can't speak on behalf of your mom.
What's
your name?
Robert Hicks.
You have to speak on behalf of Robert Hicks.
Okay, that's what I'm doing, actually.
Okay, that's the only person you can speak on.
So, what I'm understanding
It's totally against what he's doing.
What? I'm
Because
confused.
he's buying a house for $1 that he's not buying.
That's not before this court.
Okay.
That's why I asked, was there an issue with the circuit court?
Okay. No,
There's nothing
because
pending at circuit
what I
court?
understand, when we were here last time and you gave us to understand that.
Yeah, but he also told.
Okay, both of us aren't going to talk. You can go first and then you can respond.
When we were here last time, and you said that everything had to go through the court.
Correct.
All of the paperwork that was considered to be the paperwork that needed to confront her son about what she's doing, what he's doing, somehow to me came to me that it was MIA. I don't understand. So
I'm not following what you're saying.
In order for the paperwork for what we're doing is to go to court, the paperwork had to be presented to the court, correct?
To the
correct
court. You were trying to claim that he was not the lawful owner.
Because this
you were trying to claim that he was not the lawful owner. It's my recollection.
Okay, yeah,
and so
exactly
we don't deal with ownership of property here.
Right. This case is supposed to be in Eaton County, not Eaton County.
What's the address?
This is 4316 Dunkley Circle. He's wrong, first of all, for coming here.
Okay. It's the city of Lansing. You're saying it's in Eaton County?
It's Eaton County, not Ingham County.
It's in a 1 mile radius of.
Yes, he's in the wrong court.
If it's within 1 mile radius, it's this jurisdiction.
It's not. This house is in Eaton County.
I recognize that we deal with Eaton County cases all the time, but that doesn't mean it's not in our jurisdiction.
I didn't have that understanding. What I was doing, I was getting the information from Eaton County because of the district where the house is.
Did you file anything in the circuit court to address ownership?
Like I said.
Yes or no?
No.
Do you have something to say, sir?
Yes.
I got the paper for everything going over to my name, as far as deed, title, and everything.
I vaguely remember this situation. I know you all are brothers, and I think there's some siblings in the back, and I don't think he had the deed last time or something to that effect.
I have all.
Okay, I'm talking to him.
I had the deed, and I got another deed, but everything been transferred over to my name. Would you like to see it?
As soon as my court officer comes back.
Okay. I apologize for my
Just can't talk over each other. She's got to record everything.
Like to say something.
Yolanda, can you get the paperwork from him, please? You have something to say, sir?
Yes. He lied in court last time, said he had probation. Everything in probation, right? Probation court. Nothing's come out of that. Probate court. Nothing's come out of that. He was just stalling for time.
Okay, this is a property transfer affidavit stamped and signed by the city of Lansing Assessor's Office, 1 floor down. He's in the correct jurisdiction.
Okay.
I don't know why you believe that this is.
Like I said.
That address is not in Eaton County. It's in Ingham County. Okay. I see a quick claim deed here. It was executed this month. And so he's been moving forward, getting paperwork done, filed. You've not filed anything in the court to contest ownership. So now we're just dealing with ownership of the property. Possession of the property. He's provided documents to the court to satisfy ownership. If you want to dispute ownership, you got to do it at another court. what is your lawful right to hold over the property? Because it doesn't sound like you have one.
I'm understanding what's going on now. I didn't from the beginning.
When can you vacate the property?
Huh?
When can you vacate the property?
Well, it doesn't matter.
It's going to matter because if you don't give me a date, it's going to be 10 days
Sometime
from
in
today.
April I'm fine with that.
You're fine with 10 days
Yeah.
from today?
Sometime in April, yes. Because I'm supposed to leave on the 28th.
You're supposed to, 20th of April?
Yes.
Why are you mean move on the 28th of April?
Yes, I'm leaving this country.
Okay, well then that will be the date. Judgment in his favor for the 28th.
All right, that's fine.
You vacate. We're gonna get you some paperwork. Have a seat.
I'm understanding everything
You can prepare some paperwork.
Can I go and view the property since I haven't seen it in 6 months?
You want to go and view the property for what purpose? To secure it? Like, what do you need to view?
Make sure that everything is up, not anything been destroyed.
Ain't nothing been destroyed.
And if it has been destroyed, then what? You're gonna, because
Well,
I think you,
come back to
I
court.
think you did you file for, you did termination of tenancy? And you surveyed this property 6 months ago to make sure nothing was
That
destroyed?
was 6 months ago.
You surveyed it 6 months ago?
Yeah.
They were present when this happened?
Yeah.
Okay. That's correct, sir? Is that a yes or no? We
I
can't.
don't know. I don't know nothing about that.
Who was,
Yes,
who was, you're talking to me. Who was present?
He was. I talked to him.
Sir, he said he was not present.
He was
So,
present.
okay, well, you can do a walkthrough together, or you all can figure that out on your own. I'm not gonna get involved in your walkthrough with your family of a family home.
Your Honor, I'm going to be honest with you. Like I said, I didn't understand what was going on.
I recognize that. I think I recommended an attorney to you.
He said that I was at the home when he did a survey.
He was.
I have no knowledge.
Okay, if you all want to talk to each other, you all can go outside and do that, but not gonna do it in here. I asked him a question. He said he was not there. He doesn't remember you coming to view the home while he was there. Now, you going to visit the home while he was there? Is that what you're saying? Or did you say I'm coming to inspect the house? You talk over me one more time. Thank you. You went to go inspect the home, or you just was by the home when he was there?
No, I went in at that time inspect the home.
He was there?
Yes, he was.
What day? What day was it?
I gave him his paper, his notification paper for 30 days.
Oh, that's the day that you went to serve him, and you went inside the home?
Right.
And walked around the home?
Yeah.
Get out of my courtroom. You walked around while he was there. This man who won't even be quiet in the courtroom and inspected the property, and you didn't have a problem in there?
No.
I don't believe it.
Well, I did when I gave him the paper for 30 days.
I don't believe it. No, I'm not letting you go in there, because you go in there right now, the 911 is going to have to be involved.
Okay.
You can go and inspect the property after the fact, and if you need to file something for damages, you can do that separately. This is only as to possession. Which filed for anyways. You only filed for possession. You can have a seat. We'll get you some paperwork in just a moment. Elena Watkins versus Donald Roberts, 25-00273. Appearance, please. Judgment on you. Did you just like this for them? Why? No, I want that paperwork. And she knows how to do this paperwork. She knows how to do it. She's got multiple properties. Complete your paperwork. Don't give my step to your paperwork for you. You know what you're doing. Good morning. Good afternoon. Well, I'll call your case when you're ready. You can go review that. It's not signed by either of you.
So you just step out?
Yeah, so that you can review this paperwork and sign it, and then I'll call your case when you're ready. And Mr. Tyra, do you have a matter that's ready to go?
No, not client's not here.
Okay. Well, weren't they supposed to be here at 2 o'clock?
Yes, Michelle Corner.
But what happened?
I will go contact her.
You were here?
Yes, ma'am.
Across the hall. Is it?
Case number 0543, FHC versus Western Nash.
You can come forward. HC5 Capital versus Western Nash 25-00543. Appearance, please.
Attorney Hamdi Silva on behalf of the plaintiff.
And your name, sir?
Western Nash Jr.
Okay, Mr. Nash is here. This was for a non-payment of rent. In my understanding, there's a consent judgment.
There is, Your Honor. The rent to retain possession currently is $2,438. There are court costs of $172.85. There's a total outstanding balance of $2,610.85. We both agreed to extend the writ date to April 30th of 2025 on the condition, which is on line 10, that Mr. Nash shall pay $1,600 on 4/7/2025 and the remainder on 4/30/2025, and that he shall also make timely payments for April and moving forward. Approach, Your Honor.
Yes, on that matter, the writ date's the 28th. I gave him to the 28th. Okay. And that's how you want to proceed, Mr. Nash?
Yes, ma'am.
Okay, you understand that you have the right to be represented by an attorney today?
Yes, ma'am.
You want to give up that right? You have the right also to proceed to a trial. You can demand a jury trial. You understand that?
Yes.
You want to give up the right to trial as well?
Yes, ma'am.
Okay, so judgment will enter today by your consent, whereby you will pay the amount $2,438 plus court costs $172.85 for a total past due $2,610.85, or vacate the property no later than April 30th, 2025. Correct?
Yes, ma'am.
Says defendant shall pay $1,600 on the 7th of April, and the remaining balance should be paid by the 30th. Defendant shall make timely payments for April rent as well. Is that correct?
Yes, ma'am.
Okay, and your signatures here?
Yes, ma'am.
Yes, 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you have waived, you can return to the court and request to have this set aside, okay?
Yes, ma'am.
I'm sorry?
I got one question to ask you.
Yes.
I want to apologize for being late last time I was here.
That's not a question, but that's a statement, but I appreciate your apology. Thank you for reminding me. I vaguely remember that. I remember you stating you were fixing your car, maybe?
Yes, ma'am.
Okay. Well, you got here on time today. You got this resolved. Hopefully you can pay your rent and stay in your property.
You'll take care of it.
Okay, very good. Any additional matters for the record?
Thank you.
Thank you. You're all set.
You have a nice day.
Same to you.
This thing's not a couch.
Oh, have you seen Wetmore yet?
I have.
It's a little early.
I'm early. How long will you wait for default charge?
10 minutes after the time he's supposed to be here.
Okay. Thank you, Your Honor.
No problem. He's got 3 minutes, so 2:30.
Sure.
What's your name?
Jasmine Collins.
You're in the correct courtroom. Where's Miss Ockley?
I haven't seen.
We've not seen the attorney that's here for the plaintiff. We'll see if he's here.
Can we speak?
You have a question?
Yeah.
Yes.
Supposed to get some papers.
Yes, my court officer was working on it. I think she might have stepped out. Is due.
I'm sorry.
What money is due? This is for possession,
Yes. For
termination of tenancy.
tenancy.
Yeah, there's no money.
Termination of tenancy.
For termination of tenancy, there's no money due. It's just possession.
submitted this, adjournment.
Adjournment in which case?
Going with Sam, Roy Williams.
Today?
Yes, ma'am.
So you didn't submit an adjournment in this case. You can't step to adjourn the day of. Is this gonna be resolved? Is it the same?
Yes, basically, we just need some time to stretch out the numbers.
Okay, well, it'll process through the system and I'll get it for signature. Thank you. We need to find out if Mr. Arkanicki is in the building. A different still out there?
No, he left.
Okay, no copy. Is Ms. Watkins ready or are they still talking?
She wanted to use the one I typed up.
That's fine. Why aren't they ready though?
I told her she had to put the date in
that
she was willing to give me.
see. Jasmine Collins. What's going on? You just sent the email. I don't know if it's too late for you. You just sent what you said. No, it's too late. He's failed to appear. I'm giving a. I've already signed a dismissal. He has the right to file a motion to reinstate the case. If he does, you'll get a notice in the mail for a new court date, okay? I'm gonna give you a copy of dismissal in just a moment.
I just wait for the thing to come in the mail.
For if he files to set aside the dismissal, then you'll get something in the mail to the address to tell you the new court date.
Oh, yeah. Oh, yeah.
Smart. Okay, let's see. Are we ready, Ms. Watkins?
Yes.
Lena Watkins, Living versus Donald Roberts, 25-00273. Sir, what's your name?
Donald Roberts.
Oh, okay. Today was the date that was scheduled for hearing. My understanding is that you all did negotiate a conditional dismissal. Okay, what are the terms?
Defendant agrees to pay the past due amount within 20 days allowed to him by me, and defendant is currently receiving assistance from services. So we hope to give him a chance to pay all amount he owes rent.
He's going to pay $10,000 and $15.07 plus $243.10 in court costs for a total past due $10,259.17. And he's going to pay that by April 28th. Is that a yes?
Yes, ma'am.
Okay. You understand that you have the right to be represented by an attorney in this matter?
I do.
Are you going to give that right up today to represent yourself?
I will.
You also have the right to proceed to trial. You could have demanded a jury trial. You understood that, right?
I did.
You wish to give that right up as well?
I do.
Is this for rent due to the end of this month? The 31st of March?
Yes.
So the matter will be dismissed today upon the conditions that we just went over. You'll pay the past due total, including court costs, $10,259.17, or you'll vacate the property in question by the 28th of April. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you've given up, you can return to the court and request to have this set aside, and we'll set it forth here. Impartial performance will not satisfy this. Watkins wants all of her money. You can't pay part of it. You got to pay all of it by the 28th if you want to have this continue to be dismissed. Otherwise, if you don't comply fully, she can get a judgment against you without noticing you of any new court dates, okay? Do you have any questions at this time? Any other matters on this? I'll get your copy in just a moment. You're all set. Thank you. Same to you. He was. I did see him over there. He's not over there anymore. Which matter is he on?
He is covering for Brown.
Okay. Is Miss who's here for Tolzman? Is Tolzman here?
No, one's checked in.
Not seeing opposing counsel. Matters. Jinx versus Burgess.
Should have been a CBA, or not a CBA, adjournment now as well. I did submit that one yesterday. That helps.
Let's see why they don't close us off the docket. Later. I gotta sign this up. Yeah, so that one's obviously. Mr. Wetmore, I think we're still getting money order. And, are you waiting on a matter?
I am. It's an adjournment on 2:45.
It's an adjournment, you said?
Yeah, she's not going to show up. And it's Alexis Hawley. She has college orientation. We agreed to a 1 week adjournment with her.
You want a new date?
If possible.
Said she has college, you said?
College orientation.
Okay.
She was going to miss out on the scholarship if she didn't show up to it, so we just agreed to adjournment.
You have a date for that? That's April 9th at 2.
That's fine.
Okay.
Thank you.
No problem. Repeat that one.
I'm inclined to just adjourn this. Defendant, he brought
Cash.
He brought $2,100 in cash, and I told him to get a money order.
Okay.
So I don't know how long he's going to be. So we just adjourn it.
April 9th at 2:30.
April what?
9th at 2:30.
April 9th at 2:30. All right. And I'll wait for him in case he comes.
Sounds good. Thank you.
Thanks.
Is ready on something? Mr. Bach, ready on something?
Yes, we're not sure.
Which one?
I've got the Rasen Booker and Lingenfelter.
Okay, Aras Booker versus Lingenfelter 25-00267. Appearance for the record.
Yes, good afternoon. Your Honor, Ronald Bach here for the plaintiff, Rasen Booker LLC.
Okay, this was a reset. I think it was a small balance that was owed. Did you all resolve this?
Yes, Your Honor. The tenants have already vacated it. So what we've done is we've agreed to a consent order for additional dismissal only for the money balance. As long as he pays, the case will stay dismissed. If he doesn't pay, he gives the plaintiff the ability to come back and seek the money.
Okay, so they've not paid the balance.
They've not paid the balance, but they have vacated.
Okay.
So this is my first time doing it this way.
I've done it this way before. The problem is that I only have one person here.
Correct. And
so the other person's either going to have to be defaulted or you're going to have to dismiss it.
We're going to dismiss it.
Okay. Dismissal.
I will.
Okay.
And this is the balance is $2,139.73 plus the cost of $302.58, for a total of $2442.31. You're going to start paying $300 a month starting April 15th.
That's correct, sir?
Yes.
Okay, you understand that you had the right to be represented by an attorney today?
Yes.
You want to give that right up?
Yes.
You also have the right in this matter to proceed to a trial. You could have demanded a jury trial. You understand that?
Yes.
Anyone threatening you to get you to give these rights up?
No.
This was for rent that was due through what period?
Is everything due even with the damages after move out?
What's
through
the
today?
31. Okay. And so you're going to pay $2,442.31. You vacated the property already, but you'll pay $300 per month starting April 15th, and you'll make that payment until paid in full, correct? Okay. You understand that partial performance won't satisfy this. So if you miss your payments, judgment can enter against you. You will not get a notice of a new court date, okay?
Yes.
Okay. Do you have any questions? In 3 business days from today's date, if once you leave here you realize you misunderstood your rights, you can return to the court and request to have that set aside, and then we'll explain how you misunderstood your rights, okay?
Very good.
We'll get you a copy in just a moment, as well as a copy of the dismissal for Andrea Lingenfelter.
Thank you.
No problem.
Vivian Smith just logged on.
No, I'm. She's gonna bring you a copy when
In cases, additional dismissal.
I'm sorry.
In cases of conditional dismissal.
I will seek a dismissal form and get back. Did she do that?
I'm not sure. You do the dismissal. You can come back.
Buchanan has them laying out on the table.
That would be smart.
You can steal one from her. Thank you. Sorry.
I just gotta check a box.
Dismissals for Andrea, right?
Yes. You should do what they do, leave like dismissals for the attorneys. This is a attorney dismissal. I'm not ordering dismiss. And then you, Mr. Block, he can he sign it. He might be in another courtroom. I have to go find him. Is he coming today? Or is he coming via Zoom? He's got more than one matter. Mr. Kesky?
Yes,
Okay, are you ready on your matter?
I believe so, yes.
Please start your video. Thank you. Okay, let's see here. And this is Vivian Smith. Can you hear us, Ms. Smith? Oh, you're muted. I
Yes,
can't hear
I
you.
can. Yes,
Okay.
I can.
CDM file. Okay, this is the matter of Hold'em Investments versus Vivian Smith, 25-00863. Counsel, can I have your appearance, please?
Good afternoon, Your Honor. Don Keski for the plaintiff. Also on Zoom is Kip Wilson from Renaissance Property Management, agent for the owner.
Okay, and also the defendant is present via Zoom. This was the date that was scheduled for him to put is it a conditional dismissal on the record?
That's correct. We filed a conditional dismissal.
Okay. You can put the terms on the record.
According to the conditional dismissal, the amount of rent owed through March is $5,090. Court costs of $161.65 for a total of $5,251.65. The agreement is that the defendant is to pay $3,000 in certified funds or money order by 3 p.m. on March 14. $500 a month by the 15th of each month, starting April 15 until the balance is paid in full, and all future rent payments are due on or by the 1st of the month, starting on April 1st, and the RPM will waive fees relative to April through July rent as long as all payments are made according to the settlement arrangement and the consent order.
Okay, and Ms. Smith, is that completely accurate as to how you want to move forward?
Yes, yes, Your Honor.
Okay, you understand that you have the right to be represented by an attorney?
Yes.
Are you giving that right up today?
Yes.
You also have the right to proceed to trial. You could have had a jury trial if you had demanded a jury trial on this matter. Did you understand that?
Yes.
And you're going to give that right up as well?
Yes.
Is anyone threatening you to get you to give these rights up?
No, ma'am.
Any promises extended to you for you to waive those rights?
No.
What was the promise?
Oh, no. No promise.
Okay. Okay, so partial performance of the agreement will not satisfy it. So you got to do exactly what you said you were going to do in Section 3 of the agreement. Otherwise, Mr. Keski can file to have judgment entered against you for failure to comply with this agreement, and you will not get notice of any future court date. Do you understand that?
Yes.
Do you have any questions for the court?
No, Your Honor.
You have 3 business days from today. If after you leave the virtual courtroom, you realize you misunderstood your rights, you can return and request to have this set aside and explain how you misunderstood your rights, okay?
Yes.
Unless you have any questions for me, you're all set for today. Thank you.
Yeah.
You're welcome. Thank you.
Yep. Thank you, Your Honor.
Thank you. Ms. Smith, you're free to go. What do you all have?
Michelle Courtney.
Carolina Flats versus Michelle Cornman, 25-00866. Appearance, please.
Good afternoon, Your Honor. Attorney Hans Silva on behalf of the plaintiff.
And Attorney Elijah Tyler, 206-242 on behalf of the defendant, Your Honor.
Okay, today was the day that was set for a hearing for non-payment of rent. You all have resolved this matter, correct?
We have, Your Honor.
Put the terms on the record, please.
Yes, Your Honor. The total rent due at this time is $2,524.19. Court costs are $180.20. The total is $2,704.39. The conditions state that the defendant agrees to pay her portion of the rent by the 6th of each month, plus an additional $500 to be paid by the 4th Friday of the month for the months of April, on April 25th, May, on May 23rd, and an additional $304.39 payment coming in June on June 27th. The defendant will also continue with the DHS, who has already agreed to pay $500 as well. I'm sorry, I'm just writing some stuff out.
Yes. Okay, Ms. Corman. Stand next to your attorney.
Oh, sorry.
Okay. That's how you want to proceed. You want the matter dismissed today upon the condition that you will pay the past due rent amount. Okay, that's $2,524.19 plus court costs of $180.20 for a total due $2,704.59, correct? You understand that you had the right to proceed to trial? I can't hear you.
Yes.
Okay. Do you want to give that trial right up, or you want to have a trial on this matter? No trial needed, you're going to give it up. Okay. And no one's threatening you to get you to give up your trial? No one's promising you anything to get you to give up your trial?
No.
Okay. Okay, and so you understand that partial performance will not satisfy this agreement. You have to do exactly what you say you're going to do here in section 3 if you want this matter to remain dismissed. Do you understand that? If you don't, then what happens is the plaintiff's attorney can file to get a judgment against you, and they don't need to give you a new court date for that, okay? Do you have any questions?
No.
You have 3 business days from today's date to return to the court and request to have this agreement set aside if you realize you misunderstood the right you gave up, which was your right to trial, okay? You're all set. We'll get you a copy.
Thank you, Your Honor.
Thank you.
I know I break my arm.
That's exactly.
Okay, Mr. Keski, your other matter is present.
Okay, Your Honor, great.
Okay, on the record and the matter, Harrison, I'm sorry, 3017 Vikings versus Harrison Fisk, 25-00869. Counsel, can I have your appearance, please?
Good afternoon, Your Honor. Don Keski for the plaintiff. Also on Zoom is Kip Wilson from Renaissance Property Management, the agent for the owner.
Okay, and the defendants are present via Zoom. Please state your name for the record.
Alice O'Hara. Michael Fisk.
Okay, today was the date scheduled for a hearing for non-payment of rent, but the parties have negotiated a conditional dismissal. Counsel, can you put the terms on the record?
Yes, the conditional dismissal provides for a payment arrangement relative to back rent of $4,738.52 through March. Court costs of $192.05 for a total of $4,930.57, with the defendants to pay $2,480 on or by March 25th in certified funds or money order, and to pay on April 1, $1,565 for April rent, and the remaining balance of $2,450.57 to be paid on or by April 17. And any late fees for April that should post to the account RPM will waive if the payments are made in accordance with the terms of the settlement agreement and the consent order.
Okay, and so they have made that payment yesterday, is that correct?
Yes, we did. Yeah.
Okay, very good. And so the statements as to the agreement and how much you're going to owe and pay and the way and form or dates that you're going to make those payments, that's accurate as to both you and Mr. Harris or Fisk?
Yes. Yes, Your Honor.
Okay. Okay. Do you both understand that you have the right to have an attorney represent you today at this hearing?
Yes, we do, Your Honor. Yes, Your Honor.
Do you want to give that right up?
Yes. Yes, Your Honor.
Okay, you also have the right to proceed to a trial in this matter. You could demand a jury trial, but did you want to waive your right to a trial to have this matter dismissed upon the conditions that you'll make payment according to Section 3 of this agreement?
Yes, Your Honor.
I didn't hear it from both of you.
Yes, Your Honor. Sorry.
Okay. Okay, so you understand partial performance will not satisfy this agreement. You have to comply fully to the terms in Section 3. Otherwise, if you don't make the payments according to how you state you would in Section 3, Mr. Keski can request to have judgment entered against you. You will not receive notice of a new hearing if he does do that. You understand that?
Yes, yes, Your Honor.
Very good. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you have given up, you can return to the court, request to have this set aside, and then explain how you misunderstood your rights. Do you have any questions at this time?
No, Your Honor. No, we don't, Your Honor.
Any additional matters for the record, counsel?
Nothing else. Thank you, Your Honor.
You're all set.
Thank you, Your Honor. Have a good day.
Yeah.
Same to you.
Yeah. Thank you and bye.
Thank you, Your Honor. Thank you.
Thank you. You all ready on a matter? Which matter is this? This Cremines or?
Yes, Cremines, Denny.
Okay. You're ready to proceed?
We are.
Paul Dennings versus Michael and Laura Cremines, 25-00527. Appearance, please.
Good afternoon, Your Honor. Timothy Young, appearing for the plaintiff, Paul Denning, who is president of counsel table.
No one's in the hallway. How do you want to proceed?
Your Honor, I believe we would just proceed to have this matter heard by the court. I don't know that there's a whole.
They failed to appear.
Right.
So you want a default?
I would like a default. That's
default's granted. You have paperwork, or do you want?
I do, Your Honor, and let me just fill out. I didn't know whether it would be by hearing or consent. So
by default.
I'm going to just provide the court with the default judgment, and I'm not sure what the service fee I had. We're not requesting damages. We're just simply requesting possession, which has actually been given back to my client. We're just trying to get a writ so that we can empty the basement of all of their personal property.
I'm confused. They've already moved out of the property?
They have not moved their personal property. They have been.
They just vacated and abandoned their property?
Exactly.
The service fee was the $56.20, so put times 2. Yeah, for the service fee, however.
Service fee was $56.20, filing fee, and that's really all that we're asking be charged.
56, what, 20?
20, yes.
Filing fee. I don't believe the article is in section 2 because it's only for possession. I hear that when they indicate that they can pay that and stay, and they cannot.